With our association in the past, has made some presentations at annual meetings and has a lot of great information about the withdrawal liability um, subject and trade shows as it relates to your relationships with your unions and their pension funds. So with that, let me step aside and introduce to you Will Daniels. Thank you, Will, for being here.
So first, I'd like to thank Jim and the EACA for inviting me to speak on this topic of withdrawal liability in the trade show industry. A very important topic and one near and dear to my heart as I try to inform and educate employers so they're not surprised by what I have coined as the hidden liability. As Jim mentioned, I'm an attorney with Lehner Mution. We are located in Chicago, but my practice is national. I represent employers from coast to coast, and anything regarding withdrawal liability is not out of my wheelhouse. I've represented employers who've had demands for withdrawal liability as low as 49,000 and a few whose withdrawal liability demand was over $30 million. So with that, I'd also like to say that we are a management firm. We do not represent unions. We do not represent union trustees on pension funds. We do represent several pension funds, some with withdrawal liability, but we represent the management trustees of those funds. With that, let's talk about a brief history of withdrawal liability and where this problem arose. For those of you who were around in the 60s and may recall, there were several large pension funds that had failed. These were in industries relating to declining industries, the coal industry, the train industry, and as a result, employees who had worked for these employers for 40, 60 years and had been promised benefits upon their retirement ended up receiving nothing. As a result, Congress saw that there was a problem here, and the main problem they identified was that these pension funds, both single employer and multi-employer, were really only reviewed and policed by one government agency, that was the IRS. And as we all know, the IRS has one main concern, and that is to get money for the federal government. So the only thing the IRS really focused on with regard to these plans was that employers were not putting too much money into the plans. Because any money that goes into a pension plan cannot be taxed. It can't be taxed until it comes out, and the government was fearful that this was going to be a tax shelter that was abused by employers. So they limited the amount of money that could go into these plans, and that is kind of going to be an overreaching theme with regard to withdrawal liability. So in 1974, Congress passed the Employee Retirement Income Security Act, which brought in the Department of Labor to monitor and review these plans. However, even the initial iteration of ERISA, the Employee Retirement Income Security Act, did not address multi-employer plans. That didn't come until the end of the 80s, and a few big cases that arose specifically relating to corruption within the multi-employer plans. Anybody who's seen the movie Casino will recall that the Teamsters were running the Central States Southeast Southwest Pension Fund, a pension fund located in Chicago that was basically a bank for the mob to take money and invest in casinos in Las Vegas. Now, oddly, while the mob was in control of the Central State Southeast Southwest Pension Fund and money was being invested in casinos, there was always plenty of money to pay benefits. It wasn't until after the federal courts took that pension fund over that it took a nosedive and now has liabilities in the billions of dollars. So in 1980, Congress came back to this issue and developed the Multi-Employer Pension Plan Amendments Act, the MPPAA. And these rules were designed to try and resolve issues specifically relating to funding. Now, at this point, being a management attorney, I would love to be able to turn and say, hey, this is the union's fault, this is the pension fund's fault, labor's always trying to hurt management, and this is really their issue. Unfortunately, it's not. And this is not a labor versus management issue. This is an industry issue. And it involves a situation where, on the one hand, we have the government limiting how much money can go into these plans, but on the other hand, the unions and the employers negotiate higher benefits for their employees. Sometimes this is done to avoid a wage increase. If we can't afford a wage increase, we'll bargain through collective bargaining an increase to the pension benefits. The problem is that because the amount of money is capped as to what can go into these pension benefits, if we were in a very static environment, we would have enough money to pay the benefits. But whenever we have a hiccup in the market, think 2008, where all of a sudden there's a great shortfall, now we have a big problem because we don't have a cushion sufficient enough to absorb some of these types of problems. And that's exactly what we're seeing today. So what's the basis for withdrawal liability? Well, the basis for it is the contributions that you, the contributing employer, make to the pension plan. And though it may sound counterintuitive, the contributions, the more you make in contributions, the greater your contributions, the more exposure you have to withdrawal liability. You would think if I'm putting a lot of money into the pension fund, it should be well funded. But the reality is that this determines how much your share of the withdrawal liability is, and the more you put in, the more your share increases. Now, contributions are usually made monthly, and delinquent contributions are also covered under ERISA, and collection is mandatory, which is good because the more money the fund collects with regard to these contributions, theoretically, the less your withdrawal liability or anybody's withdrawal liability should be. So what exactly is withdrawal liability? Withdrawal liability results when you take a snapshot of the date an employer withdraws. And on that date, the fund actuary looks at all of the benefit promises made by that pension fund to all employees, not just the employees of your company, but all employees who are contributing or whose on behalf they are contributing to the pension fund. And they say, okay, if we had to pay these benefits today, how much would it cost to pay those benefits today? That's going to result in a very large number. And then they say, well, then we have to determine what are the net assets of the fund as of today. And then if there's a difference between those two numbers, so they take the cost of the promised benefits minus the cost of the assets, and if that results in a shortfall, then that's the unfunded liability, and that is what causes withdrawal liability. Now, you may think, well, I've been a union contributing employer for the past 40 years. I've never missed a contribution. I know I've made my fair share of contributions. Why should I have any withdrawal liability? And this is another problem with the law. Unfortunately, you're not responsible for just your employees. You're responsible for all employees of all contributing employers. So if you withdraw from a fund that has an unfunded liability due to other employers not paying their fair share, you too will have a portion of that unfunded liability assigned to you as withdrawal liability. Now, what could cause a withdrawal from a pension fund? There's several factors. Closing a facility, ceasing to perform work in a certain area, bargaining out of a plan, ending the relationship with the union, business closure, bankruptcy, sale of the business. Anything that results in you no longer having an obligation to contribute to the pension fund can trigger a withdrawal. There are two types of withdrawals. The first we'll talk about is a complete withdrawal. This occurs when you completely cease to have an obligation to contribute under the plan. So for example, let's say that you decide you want to retire and you close your business. You no longer have employees. You no longer have an obligation to contribute to the pension plan. That will result in the triggering of withdrawal liability if the fund is underfunded. So going back to the prior slides, if there's a deficit there, then you will be assessed withdrawal liability based on your business closing. Now within the 7th and 8th circuits, all means all. So let's say you downsize and eventually you're going to get rid of or close the union operations within your company. So long as you have at least one union employee, it will not result in a complete withdrawal. If you negotiate out of the plan or go non-union, that could result in a complete withdrawal. And the problem here too is that some of the triggers for incurring withdrawal liability may not be within your control. Obviously, if you close your business or sell your business, these are things that you control. But it is possible that the union could disavow your company, forcing you to go non-union, or the pension plan could reject your collective bargaining agreement, thereby, even though you remain union, you remain with union employees and with the union, you will no longer be able to make contributions to the pension fund. That too will trigger withdrawal liability. And it doesn't matter how the withdrawal liability is triggered or who triggers the withdrawal liability, it's still your withdrawal liability. It is not a defense to say, I didn't intend for this to happen, the fund caused this to happen, or the union caused this to happen. The other type of withdrawal liability is known as a partial withdrawal, and this is the worst of all worlds. A partial withdrawal results in a large liability being assessed against the company. However, additional partial withdrawals can occur each year after the year in which the initial partial withdrawal occurs, or even a complete withdrawal, and you do not receive a dollar-for-dollar credit with regard to these withdrawals. So each successive withdrawal liability, although decreasing in amount, results in additional liability that likely would not be triggered if you had incurred a complete withdrawal versus a partial withdrawal. So how do you incur a partial withdrawal? There's three ways to incur a partial withdrawal. The first would be to close a union facility, or the second one would be to negotiate out of one but not all of your union collective bargaining agreements, and then continue to perform the work covered by that facility or covered by that collective bargaining agreement in a non-union setting. Those are rather atypical and are easy to spot. You know if you're going to close a union facility or if you're going to negotiate out of a collective bargaining agreement. You certainly know if you're going to transfer that work from union to non-union, and that can be avoided. The third trigger, though, is probably the most dangerous, and that occurs when you have a decline in your contribution-based units. So what's a contribution-based unit, or a CBU? That is the basis on which you are making contributions to the pension fund, and it's a unit of the employee's work. So you might be making contributions based on the hours your employees work, or it could be the days your employees work, the weeks or the months your employees work. So for example, let's say that your contribution-based units were $5 an hour. For every hour your employee works, you're going to contribute $5 to the pension fund. If you are downsizing and you incur a 70% decline in the overall contribution-based units, that can trigger a partial withdrawal. So what occurs when you pay withdrawal liability? It's important to realize that the ERISA provides pension funds different options for actually calculating withdrawal liability. So if you withdraw from one fund, it may use option one, maybe the presumptive method for calculating withdrawal liability, and a different fund could use a completely different manner of calculating withdrawal liability. Generally, though, they all share kind of a common theme, and that is they are going to assess a pro rata share of the pension fund's unfunded vested benefits. As you recall from a few slides before, the unfunded vested benefits is the difference between what is promised by the pension fund to all participants versus the amount of assets they have. That results in an unfunded vested benefits. Your pro rata share is determined by looking at your contributions. Typically, a fund will look back 10 years and they'll calculate the total amount of contributions you made to the fund over that 10-year period. They'll then divide that by the total number of contributions made by all contributing employers to the fund over the same period. Now that's going to result in a very small fraction, but when you multiply that small fraction by $1 billion, it comes out to a large number. So it's important to realize, though, that this withdrawal liability is not a mortgage or a car payment. Once the liability is triggered and calculated, the fund can and will include interest in the payments. However, they cannot demand the payment of the entire amount up front. They have to put the employer on a payment schedule. Again, that payment schedule can include interest, but they cannot require you to pay off the entire payment within a year. In fact, the fund is limited by how much they can collect on an annual basis, and we'll talk about that formula in a bit. Furthermore, if that annual amount is insufficient to pay the principal over a 20-year period, then under most circumstances, any payments that are not made after the 20 years in principal are forgiven, unless there's a mass withdrawal, and we'll talk about that in a little bit. So there are some special rules regarding the paying of withdrawal liability. The first is the de minimis offset. And the de minimis offset is basically exactly what it sounds. If your liability does not exceed $50,000, then everything is excused. So if they assessed your liability and it was $45,000, you would pay nothing. If the liability does not exceed $100,000 but is over $50,000, they simply subtract $50,000. So if your liability was assessed at $65,000, the de minimis exception would kick in to knock off $50,000, and you would actually end up paying $15,000 in withdrawal liability. Again, keeping in mind that anything you don't pay is reallocated to all remaining contributing employers who are making contributions to the fund and increasing their withdrawal liability. Finally, if the liability exceeds $100,000 but is below $150,000, then the $50,000 offset is reduced dollar for dollar, so that if your withdrawal liability is assessed at $149,000, they're only going to subtract $1,000 from that. So you would end up paying $148,000. And if your withdrawal liability is over $150,000, they don't subtract anything at all. The second special rules relate to mass withdrawal. A mass withdrawal occurs if all contributing employers withdraw from a fund within the same year, or if over a 3-year period, substantially all contributing employers withdraw from the fund. This is a terrible situation and only occurs typically in situations where the fund is so poorly funded and in a dying industry that the contributing employers no longer can maintain their participation in the fund, or the fund can no longer maintain the participation of the contributing employers. Under these circumstances, many of the rules that are good for employers, and there's not many, will actually go away. So for example, the 20-year cap we were talking about earlier, it is possible that the 20-year cap can be lifted if a mass withdrawal occurs, and instead of making payments, annual payments over a 20-year period, you could be making these payments into perpetuity. So how is the amount of repayment determined? And this is the formula that determines your annual amount. What is the maximum that the fund can charge you per year in order to pay off the withdrawal liability? What they do is they look back at the 10 years that occurred prior to the year in your withdrawal, and they find the highest 3 consecutive years of contribution-based units. Remember, we talked earlier, contribution-based units are what your employees are working and the basis for making contributions to the fund. It could be hours, could be days, could be weeks, whatever. So they'll look for the 3 consecutive highest years over the past 10 years, and then they'll look at the highest rate for looking back 10 years from the day that you actually withdraw. Now, I assume that everybody's rate only increases. It's very unlikely that a pension fund contribution rate actually decreases. So likely the rate in effect as of the date you withdraw is your highest rate. They're going to multiply that highest rate by the highest 3-year average of CBUs, and that's how much the fund can charge you annually to pay off your withdrawal liability. For example, let's say that you've always had 10,000 hours of CBUs per year. So your average is going to be 10,000 for the CBU portion. Let's say that the rate is $5 an hour as of the date you withdraw, and that's the highest rate that you paid over the past 10 years. 10,000 times 50 is 50,000. The fund can collect from your company $50,000 a year over a 10-year period in order to pay off the withdrawal over a 20-year period in order to pay off the withdrawal liability. So who pays the withdrawal liability? Well, obviously it would be the withdrawing employer. That would be any employer that has a participation agreement with the pension fund, a collective bargaining agreement with the union, possibly a venue agreement. I've seen for the Pittsburgh Convention Center, they have a venue agreement in which you sign in order to put on a trade show within the Pittsburgh Center. And then as a part of that agreement, it also says that you will be making contributions to several different funds. Any written document that requires you to make pension contributions can establish that you are the withdrawing employer. And again, once you cease to have an obligation as the withdrawing employer, that will trigger the withdrawal liability. However, that withdrawal liability does not stop with just the contributing employer. We also have to look at the controlled group of the contributing employer. So for example, let's say that I had a trade show business and I owned 100% of the trade show business. And then let's say that I also had owned 100% of a McDonald's. In fact, let's say that my father left that to me. I inherited ownership of a McDonald's. When I withdraw from the pension fund, if the trade show business does not have enough money to pay the withdrawal liability, anything that the trade show business doesn't pay, the fund can come after my McDonald's to pay. So typically, controlled groups are, first off, controlled groups are determined as of the date of withdrawal. And in order to determine if you have a controlled group, if you own 80% or more of one or more businesses, each one of those businesses that you own 80% or more of is part of the controlled group. There's also common ownership amongst 5 or fewer owners. So let's say myself and my best friend Tony each own 50-50 3 companies. All 3 companies are in common control. Even though we each own only 50% of it, we don't own 80% or more individually, because the same 2 people own 100% of all 3 companies. They are all part of the same controlled group. Now you can try to break that controlled group. Let's go back to my example with the McDonald's. Let's say I own 100% of the trade show and I inherited 100% of McDonald's. I could gift or deed 50% of the ownership of the McDonald's to, say, my distant cousin. Now I own less than 80% of the McDonald's, and I would not that would not be part of the controlled group with my trade show business. But it's important to consider another overall theme of withdrawal liability, and that is the evade or avoid issue. Any action done by a contributing employer to evade or avoid withdrawal liability can be disregarded by the pension fund such that they can assess, collect, and demand withdrawal liability without considering the action taken that would ordinarily say break the controlled group or lessen the withdrawal liability or even avoid withdrawal liability. Can there be personal liability? The answer here, unfortunately, is yes. So let's again go back to my example. I own 100% of a trade show, I own 100% of McDonald's, and I own 100% of the property upon which the McDonald's is operating. Now, ownership of 100% of the trade show means that the trade show is part of the controlled group with both the McDonald's and the property upon which the McDonald's operates. Let's say the trade show is a corporation, the McDonald's is an LLC, but the property on which the McDonald's operates is simply held by me as a person. Because there is no corporate or limited liability protection there, any liability will pass through the property to me personally. Let's say that the trade show goes bankrupt and the trade show business incurs withdrawal liability of $1 million. Well, none of it's paid by the trade show business because the trade show has gone bankrupt. So now that liability passes through to the McDonald's. Well, let's say the McDonald's only has $500,000 worth of assets, including the value of the property upon which the McDonald's operates. Because there's still $500,000 of liability, and because the property is not being held in some sort of limited capacity, limited liability capacity, such as a limited partnership, corporation, whether it's C Corp or S Corp, limited liability company, that means that I am now personally liable for the remaining $500,000 owed to the fund. And theoretically, they can come after my assets. And bankruptcy, as we'll talk about later, is not necessarily a protection. In fact, we'll talk about it right now. Bankruptcy is not a protection. It typically determines the plan's position in recovering assets through the bankruptcy proceeding, so that 50% is treated of the liability is treated as an unsecured creditor, and the other 50% is subordinated. So depending on the bankruptcy laws in your state, I live in Illinois and we have terrible bankruptcy laws. Whatever's not protected can be liquidated and paid to the fund in order to pay off that withdrawal liability, assuming that there was personal liability. Trustee collection of withdrawal liability. So how does this occur? When a withdrawal is triggered, the first thing that will occur is that the pension fund will issue a demand letter. Now, unfortunately, it's hard to tell when you'll actually get that demand letter because it really depends on the plan year of the fund, when you withdraw, and the information they have as of the date of your withdrawal and how they calculate the withdrawal liability. It is possible that you could get a demand for withdrawal liability payment the month after you withdraw. It's also possible that you may not get a withdrawal liability demand for over a year after you've withdrawn, because in a typical situation, the plan has to wait until the end of the plan year in which you withdraw in order to determine exactly what type of assets it has as of the end of that year, so that it can accurately figure out what its unfunded liability is. Again, remember, they made promises to all these participants. They know how much that's going to cost as of the date of your withdrawal. But when they look at the assets they have to do that on an annual basis. They can't piecemeal that together. So they may have to wait until the end of their plan year in order to determine how much those assets are before they can subtract that out from the promised benefits and come up with the unfunded liability. The employer may also be required to complete a statement of business affairs. This is a very invasive questionnaire. It will ask you things about your ownership, it may ask for tax returns, it may ask what other pieces of property or other businesses you own, who else owns them, and it's tempting to kind of circulate it into the trash and say, well, I'm not going to fill this out. Unfortunately, the law requires you to do so. And there's often tricks on these statement of business affairs, legal things, where if you don't know how to answer a certain question and you just check a box or fill in information, you may actually be helping the fund to establish liability not only for yourself personally, but also other members of your control group. So it's very important to have an attorney who knows what they're doing either review your statement of business affairs or help you complete that statement of business affairs. And what happens if you default on payment? As we said earlier, the fund can't require you to pay 100% of your withdrawal liability in a lump sum. They have to put you on a payment schedule with the maximum annual amount. Now, that maximum annual amount can be collected either monthly, quarterly, or annually. Typically, we see monthly or quarterly. I don't know of any funds that wait an entire year before they collect. The payments will start 60 days after you receive the demand letter. If you do not make a payment, you have to be given a notice to cure. And that notice to cure will say you have 60 days from the date of this, you have missed a payment, you have 60 days from the date of this letter to correct that, or we are going to default you. If you fail to make the payment within the 60 days after the notice to cure is received, then the fund has the ability to accelerate the entire payment. So you may owe $30 million. It turns out that with a 20-year cap, you may have only paid $1 million, but if you default on any payment, they can accelerate the entire $30 million, and you no longer have the ability to argue that you should have only paid $1 million of it over a 20-year period, because they can collect everything from you up front. It is important for the employer to know which entities are employers. So if the company has ever been in a control group, not only do you have to arbitrate the issue of withdrawal liability, but you would also need to arbitrate whether the employers who the fund is saying are part of the control group are in the control group or not. For example, going back to my McDonald's, if I had, years before my withdrawal occurred, I had deeded the McDonald's over to a distant cousin. If the fund didn't know of that deed, or the deed hadn't been properly recorded, if the fund comes after the McDonald's can't ignore the demand for withdrawal liability. They too would have to make a challenge in writing with regard to that withdrawal liability assessed against them. Now, any challenges that you make, unfortunately, the statute provides for a pay now, litigate later mentality. So even if you have good arguments, maybe the contribution history the fund is using is wrong, you don't like the actuarial valuations that are being used, whatever your challenges are to the pension fund, unless it's purely an evade or avoid issue, you must make payments within the schedule while the challenge is occurring. So if you default and the fund is able to accelerate your payments, it cannot collect, while you have a challenge pending, they cannot collect 100% of the withdrawal liability assessed against you, but they would be able to collect 100% for each payment that's owed. Arbitration is mandatory in these situations. So unfortunately, it's rare that you'll be able to go directly to the court. You must arbitrate 90% of these issues up front with an arbitrator before going into the court system. So how exactly do we challenge withdrawal liability? Well, when we get the demand letter, the first thing we have to do is determine whether any challenges exist. We have 90 days from the receipt of the demand letter to issue a request for review. And that request for review needs to be in writing, and it needs to clearly outline every challenge that you're going to make. Furthermore, it should also request any documents that you want from the fund. Now, the document request could be a separate letter, But I like to combine them both in the same letter. I like to request review and request documents at the same time. And the reason for this, and the reason why we want to put so much detail into this request for review, is because if it does go to arbitration, we simply file that request for review as our initial document for the arbitration, which not only saves some money, but also outlines clearly for the arbitrator what the issues are and kind of presents our side of the case before the fund has a chance to respond. If the arbitration is initiated and the losing party doesn't like the results of the arbitration, they can appeal to the district court, but this is very difficult because at that level, a district court is going to be giving great deference to the arbitrator's opinion and will typically overturn it only if it's arbitrary and capricious or clearly wrong in accordance with the law. So there, as I said, there's a very limited range of issues that can be resolved in federal court instead of arbitrating, but this is really a function of case law, and it's constantly shifting. So if there's any doubt at all, you should file a 4219 request for review. That's the letter we were talking about in the prior slide, the written request for review, and then maybe also try and bring it into the federal court. I would do both rather than risk having a court say, you didn't arbitrate this, arbitration is mandatory, you blew your deadline, now you can't raise the issue. Because under those circumstances, you're going to lose and you're going to have to pay the entire withdrawal liability. The pension fund has an enforcement process. As we said earlier, you have to pay while challenging. The fund can bring delinquent actions against you in court while your fund is, while your challenge is pending. They cannot collect the entire amount even if you default, but they can collect the entire amount of payments owed. And if you miss a payment, they can charge you liquidated damages of 20%, double interest, accrued interest, and attorney's fees. So if you have the ability to make the payments, it's always better to do so rather than to risk having to make penalty payments in accordance, in addition to the withdrawal liability payments. Now I'm going to talk about several ways to limit the liability, but first I just want to throw in some disclaimers here. This is not all-inclusive. So for your specific situation, again, I strongly urge you to consult with an attorney who practices in this area and has specific knowledge of withdrawal liability in order to go over various scenarios with you to work out what's a best fit for you. The unique facts related to your specific situation can be different. And also keep in mind, again, the overreaching principle of the evade or avoid issue, which basically says that any action you take to evade or avoid withdrawal liability can be disregarded in the collection or demand of withdrawal liability. So the first way to reduce withdrawal liability is one that takes a large amount of time. You're going to reduce the contribution-based units over a long period of time. Let's say that you have 3 facilities all doing union work for trade shows across the country, and you realize that in 10 years you're going to want to shut down your business and retire, and you do not want the business to incur a large withdrawal liability. What you could start to do is decrease the amount of union work. So for example, if your CBUs are based on the hours that union employees work, the less hours they work over that 10-year period will result in a decrease in your liability. Because again, the more you pay into a pension fund, the greater exposure you have to withdrawal liability. So reduction of CBUs can be accomplished by either reducing the number of union employees used or the number of hours, weeks, or months that they actually work. It may not be possible to reduce the CBUs, though. It may not be practical for your business. It may not be practical for your market. And the collective bargaining agreement may prevent certain reductions. Also, you have to be wary of triggering a partial withdrawal. If you reduce your CBUs too quickly, over too short a period of time, and you trigger the 70% partial withdrawal, that's truly a worst case scenario. Another way that you could eliminate actually your withdrawal liability would be if you sold your company and you did it through a sale of stock. Now that doesn't eliminate the withdrawal liability overall, it just eliminates the withdrawal liability to you. But whoever buys the stock of the company will now have that withdrawal liability with them. So the withdrawal liability transfers from the seller to the buyer through the sale of stock. You can also do a sale of assets, but typically this will trigger a withdrawal liability unless the purchaser agrees to take on a portion of the liability. And this can actually work out nicely because you only have to agree to take on 5 years of liability. In some ways, under certain circumstances, we've actually had it so that there is no withdrawal liability that's transferred under this type of sale, because over the past 5 years, the fund has actually done better. We're now far enough removed from 2008 that even though overall there's liability, because over the past 5 years the fund has done better, there is no withdrawal liability that's transferred with the sale of assets. So something to keep in mind there. If you sell substantially all of your assets and the buyer does not agree to take on the liability, it's also possible to limit your liability or the liability of your company to 30% of the net sales proceeds. But under this situation, you have to sell substantially all of your assets of the entire controlled group. So in my example with McDonald's, I would have to sell my trade show business, my McDonald's, and the property. And if I sold all three of them, or substantially all three of them, to an unrelated party, then the withdrawal liability that incurs, let's say it's $1 million, I would actually only have to pay 30% of my net sales proceeds. If after the sale of those three businesses I netted $1 million, I would actually end up only paying $300,000. There's some tricky case law out there that says if your net sales proceeds are less than the withdrawal liability, you can't avail yourself of this rule. But that's a Ninth Circuit case. It hasn't been repeated, but funds will often cite that to try and jack up the cost during negotiations. So if you're thinking about closing your operations, the key advice here is to allow plenty of time for preparations. Consult with an attorney. Try and figure out what your withdrawal liability is. You can always get an estimate of your withdrawal liability from the pension funds themselves. By law, once a year, they have to provide you with an estimate of withdrawal liability. Typically, there is no downside to getting that request for withdrawal liability. However, recently, I did have a client who requested an estimate of their withdrawal liability, and this resulted in the fund finding out that there was actually a partial withdrawal that had occurred. So take a look at, you might want to consult with an attorney first, or at least take a look at your decline in contribution-based units over the past 10 years and see if you think you might be at risk for a partial withdrawal before you request an estimate of your withdrawal liability. But then if you give yourself plenty of time, we can, or an attorney can help to limit your liability, or maybe limit the controlled group, certainly prevent any personal liability against you with regard to that withdrawal liability. The timing of the withdrawal, there are two external factors that could affect the timing of your withdrawal. One is the financial condition of the pension fund to which you make contributions. The other is the financial condition of the PBGC. With regard to your fund, I've included a list. Here's the link to it because at the end of these slides, one slide has all the names of all these pension funds, and there's so many that it's hard to read. But these are basically the worst of the worst. If any of the pension funds you contribute to or your company contributes to are on this list, this worst of the worst list, that means that your plan is in critical and declining status, which means that they are likely going to go into insolvency and therefore trigger a mass withdrawal. If that's the case, you should be planning strategies for limiting your liability or exiting from that fund now, actually, today. For example, the Central States Southeast Southwest Pension Fund, a pension fund which is big in the Chicago area, is on the list and has said that they plan to be insolvent within the next 9 years. So limiting your exposure to that liability and or at least limiting who's part of the control group and whether there's personal liability is extremely important. The other consideration is the financial state of the PBGC. The Pension Benefit Guaranty Corporation is responsible for ensuring the benefits of both single and multi-employer plans. It's the government agency that kind of stands behind the plans and was put into effect again by government to avoid a situation where somebody has worked for 40 years and gets absolutely nothing at the end of the day. So in theory, the PBGC will ensure some sort of minimum benefit. However, it guarantees benefits on a sliding scale, and unless the benefit accrual rate is extremely low, it never guarantees a dollar for dollar. So currently, the PBGC is in dire financial condition. And I have in the slides the numbers for 2016. Last night, and I've been monitoring this in anticipation of speaking to you guys, the PBGC came out with the 2017 numbers. So you'll see that all my numbers are based on the 2016 PBGC report. However, there is now a 2017 PBGC report, and I'll simply say that the numbers have all gotten worse. This $61 billion of assets at the bottom of this slide is actually now $65.1 billion deficit. So the problem is that as that deficit increases, the only way the PBGC can make up that money is by increasing premiums. The premiums are paid by the fund, but is passed on to contributing employers. And so you may see increases, and we've actually started to see very creative ways for funds to increase the amounts of money they try and collect from employees beyond what the law specifically states is allowed based on, for example, the financial condition of the PBGC. So these are some more numbers. Again, everything's based on the 2016 report. It's just gotten worse in 2017. So in conclusion, I just want to make sure that everyone feels comfortable with at least learning some knowledge on withdrawal liability. And please spread the word. This is too important of an issue for people to be taken by surprise. I've had people come into my office in tears saying that they received a letter from the pension fund demanding $500,000 in withdrawal liability. They're trying to retire. This is their entire life savings. What are they going to do? And in some instances at that point, it may be very little based on the fact that they didn't properly plan for or prepare. I have a sample worksheet here, by the way. This is something that you could use to, or at least look at to determine if you wanted to calculate your own withdrawal liability, an estimate of it, rather than request an estimate from the fund, which could lead to a partial if your CBUs have precipitously declined. You could actually use the sample worksheet. What you would do is you would request the worksheet from the fund, which they have to provide to you by law, and they have to provide it to you for free. And then you would simply input your own employer obligated contributions into the column there that says obligated employer contributions, follow the math formula, and then at the end of the day it'll give you an estimate. I don't know if I think this is actually Central States, but it's old. It's from August 31st of 2015. I'm putting the sample in just so that you can see what it looks like. This is the list of worst of the worst. Again, you might want to check out the link because it's hard to read that list. And finally, are there any questions?
Thanks, Will. On terrific presentation. Anybody that might have a question, certainly you can use the chat bar below to indicate them. We'll give you a minute or so to do that. But Will, I just wanted to say once again, thanks for lots of great information. I know this is a critical issue for lots of our employees, or excuse me, I should say our members that are considering some kind of an exit strategy for their businesses or possible sales of their businesses. And I know that this is something that they'll want to be very mindful of as they look at that. I don't see any questions popping up, so I'm guessing that you've at least for now answered all of those questions, and maybe folks will want to circle back with you later on. For those of you that were in attendance today, I want to thank you for your time. This session will be available at that same link that you accessed today. If other people within your organization want to view it, it's been recorded. It'll be there in perpetuity. And that's what we'll continue to do here at EACA, is to build a library of valuable content for our members. Thanks again for your attendance today. And Will, thank you so much for a terrific
Thank you. It was
presentation.
my pleasure.